An introduction to medical malpractice in the United States. This is printed in Clinical Orthopedics and Related Research. Abstract. Medical malpractice law in the United States is derived from English common law and was developed by rulings in various state courts. Medical malpractice lawsuits are relatively common occurrences in the United States. The legal system is designed to encourage extensive discovery and negotiations between adversarial parties with the goal of resolving the dispute before going to jury trial. The injured patient must show that the physician acted negligently in rendering care and that such negligence resulted in injury. To do so, 4 legal elements must be proven. 1. A professional duty owed to the patient. 2. Breach of such duty. 3. Injury caused by the breach. And 4. Resulting damages. Money damages, if awarded, typically take into account both actual economic loss and non-economic loss, such as pain and suffering. Introduction. The concept that every person who enters into a learned profession undertakes to bring to the exercise of a reasonable degree of care and skill dates back to the laws of ancient Rome and England. Writings on medical responsibility can be traced back to 2030 BC, when the Code of Hammurabi provided that if a doctor has treated a gentleman with a lancet of bronze and has caused the gentleman to die, or has opened an abscess for the eye for the gentleman with a bronze lancet, and has caused the loss of the gentleman's eye, one shall cut off his hands. Under Roman law, medical malpractice was recognized wrong. Around 2000 AD, Roman law was expanded and introduced to continental Europe, and after the Norman conquest of 1066, English common law was developed, and during the reign of Richard Coeur de Lion, at the close of the 12th century, records were kept in the Court of Common Law and the plea rolls. These records provide an unbroken line of medical malpractice decisions all the way to modern times. One early medical malpractice case from England, for example, held that both a servant and a master could sue for damages against a doctor who had treated the servant and made him more ill by employing unwholesome medicine. In 1532, during the reign of Charles V, a law was passed that required the opinion of medical men to be taken formally in every case of violent death, and this was a precursor to requiring expert testimony from a member of the profession in medical negligence claims to establish the standard of care. In the United States, medical malpractice suits first appeared with regularity beginning in the 1800s. However, before the 1960s, legal claims for medical malpractice were rare and had little impact on the practice of medicine. Since the 1960s, the frequency of medical malpractice claims has increased, and today lawsuits filed by aggrieved patients alleging malpractice by a physician are relatively common in the United States. One survey of specialty arthroplasty surgeons reported that more than 70% of respondents had been sued at least once for medical malpractice during their career. Since medical malpractice litigation is a common phenomenon, it's likely surgeons will encounter it at some point in their careers. Once a lawsuit is filed, the defendant physician must deal with unfamiliar legal territory, where the goals, professional conduct, and procedures followed by the parties to the litigation are different from the practice of medicine. The goal of this article is to provide orthopedic surgeons an introduction to the basic concepts of medical malpractice, including the language, court structures, and tribunals that govern medical malpractice litigation in the United States. Medical malpractice law in the United States. In the United States, medical malpractice law has traditionally been under the authority of the individual states and not the federal government. In contrast to many other countries, to win monetary compensation for injury related to medical negligence, a patient needs to prove that substandard medical care resulted in an injury. The allegation of medical negligence must be filed in a timely manner, and this legally prescribed period is called the statute of limitations and varies from state to state. Once the injured person has established that negligence led to injury, the court calculates the monetary damages that will be paid in compensation. Damages take into account both actual economic loss, such as lost income, and cost of future medical care, as well as non-economic losses, such as pain and suffering. Physicians practicing in the United States generally carry medical malpractice insurance to protect themselves in cases of medical negligence and unintentional injury. In some instances, such insurance is required as a condition of hospital privileges or employment with a medical group. Medical malpractice is defined as any act or omission by a physician during treatment of a patient that deviates from accepted norms of practice in the medical community and causes an injury to the patient. Medical malpractice is a specific subset of tort law that deals with professional negligence. Tort is a Norman word for wrong, and tort law is a body of law that creates and provides remedies for civil wrongs that are distinct from contractual duties or criminal wrongs. Negligence is generally defined as a conduct that falls short of a standard. The most commonly used standard in tort law is that of so-called reasonable person. The reasonable person standard is a legal fiction created so the law can have a reference standard of reasoned conduct that a person in similar circumstances would do or not do in order to protect another person from a foreseeable risk of harm. Current medical malpractice law has its origins in 19th century English common law. English common law refers to the legal system of England and Wales and forms the basis of jurisprudence in the United States and many other Commonwealth countries to which it was exported during the time of the British Empire. Common law refers to law and legal systems that are developed through decisions of courts and judges, as opposed to laws developed exclusively through legislative statutes or executive decisions. In the United States, medical malpractice law is under the authority of the individual states. The framework and rules that govern it have been established through decisions of lawsuits filed in state courts. Thus, state law governing medical malpractice can vary across different jurisdictions in the United States, although the principles are similar. In addition, during the last 30 years, statutes passed by states' legislatures have further influenced the governing principles of medical malpractice law. Thus, medical malpractice law in the United States is based on common law, modified by state legislature actions that vary from state to state. One exception to medical liability can arise in the context of those who volunteer assistance to others who are injured or ill. This exception is embodied in Good Samaritan laws that address bystanders' fear of being sued or prosecuted for unintentional injury or wrongful death. In the United States, Good Samaritan laws vary from jurisdiction to jurisdiction and specify who is protected from liability and the circumstances pertaining to such protection. In general, Good Samaritan statutes do not require any person to give aid to a victim, although a handful of states, such as Vermont and Minnesota, specify a duty to provide reasonable assistance to an injured person at the scene of an emergency. This duty may be satisfied by calling 911 for assistance, and the violation of such a duty is usually a petty misdemeanor. Although they are not uniform in their application, Good Samaritan provisions have some general principles in common. The principle of imminent peril may affect the scope of such laws. Thus, if bystander elects to rescue a victim when there is no imminent peril and causes injury, then a court may hold the actions of the rescuer as reckless and unnecessary. Once the bystander begins rendering aid, he must not leave the scene unless another rescuer takes over, or unless it is necessary to summon needed medical attention, or if continuance of the aid is unsafe. Consent in emergency situations is implied. If the patient is unable to give consent, courts are forgiving in this regard under the legal doctrine that peril invites rescue. To summarize, under appropriate circumstances and in jurisdictions where they apply, Good Samaritan laws can immunize the responder from legal liability for death, disfigurement, or disability of the victim as long as the responder acted in good faith, according to the level of training and in rational manner. In some jurisdictions, Good Samaritan laws protect only those who have completed basic first aid training and are certified by a health organization, and provided they limit care to the scope of their training. In such jurisdictions, a person who lacks training and elects to perform first aid incorrectly can be held liable for errors. In other jurisdictions, however, the rescuer is exempt from legal liability as long as the rescuer acted rationally. The court system in the United States. Although the names given to the different judicial tribunals can vary, the structure and hierarchy of the courts is similar among the states. All states in the United States have trial courts where civil disputes are filed and litigated. And there's usually a system of appeals courts with final judicial authority resting in the state Supreme Court. The place where the case is filed is guided by the residence of the parties involved and the location of the alleged misconduct, and this place is also referred to as a venue. If a case is filed in the wrong court, it can be dismissed for lack of venue. Lawsuits alleging medical malpractice are generally filed in state trial court. Such trial courts are said to have jurisdiction over medical malpractice cases, which is a legal authority to hear and decide the case. Legal rules guide venue and jurisdiction in each state. Some towns may be located in 2 judicial districts, thereby giving the aggrieved patient an option to file suit in more than one trial court. If the malpractice claim involves the federal government acting in a federally funded clinic or a Veterans Administration facility, then the action is filed in a federal district court. Each state has at least one such federal district court, and federal courts may be appropriate for filing malpractice claims where there's a complete diversity of state citizenship exists. Example, if the parties to the litigation are from different states, or if a federal question is invoked, such as a violation of a fundamental constitutional right during the allegedly negligent conduct. In the United States, the right to a jury trial is regarded as a fundamental constitutional right. A jury trial is a legal proceeding where a group of individuals chosen from the public is asked to consider the evidence presented during the case and make a decision. The choice of jurors is guided by court rules and with the participation of lawyers from both sides. Demographic information about the jurors is known to both parties, each of whom can usually strike a limited number of jurors to assure impartiality of the jury panel. In contrast to a jury trial, a bench trial is one in which a judge or a panel of judges makes the ultimate decision. In the United States, a physician can expect a jury trial in nearly all cases of medical malpractice, assuming the case is not predisposed of a trial prior to trial. A jury trial is not the same thing as a grand jury. The latter is used for criminal indictments as does not apply to medical malpractice cases. Under limited circumstances, a medical malpractice case may be filed or moved to a federal court. This can occur if the underlying case invokes a federal question or a federal constitutional issue, or if the parties live in different states. The federal equivalent of state trial courts consists of a system of 94 United States district courts. At least one is located in each state. Like state courts, U.S. district courts have a judge and a jury panel that hear the case. And while the rules that apply to legal procedures in the United States district courts are uniquely federal, they are similar to state rules of legal procedure. The substantive law applied by federal courts to resolve legal disputes, example statutory law or legal precedent, is derived from the state in which the district court is located. Thus, if a medical malpractice case is tried in federal court, state malpractice law still applies with federal procedural rules of jurisprudence. Procedural rules have to do with legal housekeeping functions that guide the litigation process. The legal system of the United States. The system of law governing the resolution of civil disputes between parties in the United States is referred to as the adversarial system, where the respective advocates for each side in a dispute skillfully present arguments before an impartial party, such as a jury or a judge. The adversarial system is used in common law countries to resolve disputes related to negligent conduct, whether medical or otherwise. In contrast, the inquisitional system is usually found in continental European countries, based on the civil law system that is derived from Roman law or the Napoleonic Code. In this system, judges independently investigate the facts of the case and decide the outcome. The Napoleonic Code refers to the French civil code that was established under Napoleon Bonaparte and drafted by eminent jurists in 1804. The code stressed clearly written and easily accessible law and has been a major historical influence in establishing and promoting the idea of the rule of law. The code itself is derived from earlier French laws and Roman law and reflected a fundamental advancement that changed the civil law legal system of France and influenced that of other nations as well. The aggrieved patient who initiates a lawsuit before a court is called the plaintiff or complainant, and filing a lawsuit, the plaintiff seeks a legal remedy from the court. If the plaintiff is successful, the court will enter judgment for the plaintiff and issue a court order for damages, and the party against whom the complaint is directed is the defendant. In the case of medical malpractice, this party is a physician, medical laboratory, hospital, or professional organization to which the physician belongs. In litigation, cases are identified by citing the plaintiff first. Thus, a law is cited as the plaintiff versus the defendant. A medical malpractice lawsuit in the United States is initiated by filing a summons, claim form, or complaint, and these legal documents are called the pleadings. Pleadings set forth the alleged wrongs committed by the defendant physician with a demand for relief. In some jurisdictions, the legal action is initiated by a service of legal process, by physical delivery of documents on the defendant by a process server. These documents are then filed with the court with an affidavit verifying that they have been given to the defendant doctor according to certain rules of legal procedure. Legal elements of medical malpractice. In the United States, the patient alleging medical malpractice must generally prove 4 elements of legal requirements to make out a successful claim of medical malpractice. The elements include 1. The existence of a legal duty on part of the doctor to provide care or treatment to the patient. 2. A breach of this duty by a failure of the treating doctor to adhere to the standards of the profession. 3. A causal relationship between such breach of duty and injury to the patient. And 4. The existence of damages that flow from the injury, such that the legal system can provide redress. The first element is that legal duty existed toward the patient, and this duty comes into play whenever a professional relationship is established between the patient and the healthcare provider. The general idea of a legal duty is that in a civilized society, each person owes a duty of reasonable care to others. Extending this concept to the professional setting where a doctor provides service to a patient, the doctor is said to owe a duty of reasonable professional care to the patient. In practical terms, this is the easiest element for the patient to understand, since such duty is essentially assumed whenever a physician undertakes the care of a patient. A duty does not exist where no relationship is established between the doctor and patient, but when the relationship is established, such as covering patients for a colleague, covering a clinic where indigent patients are treated, or providing emergency services to an accident victim by the roadside, a duty of reasonable care follows. In some situations, for policy reasons relating to promoting medical care for indigent patients or encouraging intervention by medical bystanders in case of an accident, the law may limit the liability of the treating physician even through a reasonable duty of care was established. An exception to the duty of care is when the physician sees the patient as a non-professional, such as outside of the hospital or clinic or in some social setting. In such case, no doctor-physician relationship is established, and there's no duty of reasonable medical care owed. To show that a breach of professional duty occurred, the patient must invoke the concept of standard of care. While the precise definition of standard of care can differ among jurisdictions and the concept can prove elusive in its application, the standard of care generally refers to that care which is reasonable, similarly situated professional would have provided to the patient. To establish breach of a standard of professional care, the expert witness testimony becomes essential, since a jury of laypersons cannot understand the nuances of medical care. Some breaches of the standard of care are so egregious that expert testimony is not needed. Thus, an operation on the wrong limb is an obvious breach of duty that speaks for itself. The concept is captured in the legal term Latin for the thing itself speaks, and it's often translated as the thing speaks for itself. In such a case, the legal proceeding is abbreviated and a jury can proceed in determining damages since the breach of duty is plainly obvious. A breach of standard of care in itself, aside from being a potential quality of care concern for a medical practitioner or institution, is legally meaningless unless it causes an injury to the patient. This so what question frames the third element of medical malpractice, which is causation. To prove this element, the injured plaintiff must show a direct relationship between the alleged misconduct and a subsequent injury. Alternatively, the patient can show a legally sufficient relationship between the breach of duty and the injury, and this concept is referred to as proximate causation. The fourth and final element of medical malpractice lawsuits is called damages. A medical malpractice claim generally concludes with the calculation of damages. Since monetary damages are easy to calculate and administer, courts hearing medical malpractice cases will determine money damages to compensate the injured patient. Punitive damages are very rare in medical malpractice cases and are reserved by courts for especially egregious conduct that society has a particular interest in deterring. Examples can be altering or deliberate destruction of medical records, or sexual misconduct towards a patient. Absent a showing of damages, a plaintiff cannot maintain a cause of action for medical negligence, and thus if a fractured tibia was treated using closed reduction and cast application when a fracture pattern clearly called for open fixation, it may constitute negligence if the fracture went on to non-union or malunion, requiring multiple operations and increased expenses. But if the fracture went on to an uneventful healing despite the wrong treatment, and the patient pleaded injury from this treatment with no showing of actual damages, there would be nothing for the court to award. Process of trial. Medical malpractice cases rarely reach trial, and this is especially true of civil litigation in the United States. The reason is that the legal system is based on adversarial advocacy by respective lawyers designed to foster and promote efficient self-resolution of civil disputes. To that end, the number of legal tools have been developed, and the most important that is the process of discovery. Between the filing of the suit and trial, there's a lengthy and extensive period of discovery or information sharing and factual understanding between parties. The process of discovery is facilitated by requests of documents, interrogations, and depositions, and thus all components of extensive pretrial, out-of-the-court litigation process between parties and the legal system is designed to encourage. Documents consist of medical records. A request of medical records is usually the first step undertaken by a plaintiff's attorney to review the case, and other documents can include hospital billing information, clinic notes, and related papers. Once a case is filed, an interrogatory is a form submitted by attorneys to the opposing party, and the goal is to gather preliminary and demographic information about the party. Depositions are formal proceedings in which the litigant or party to the litigation is questioned by the counsel under oath, and a record of the proceeding is made for later use in courts. The rationale is that by requiring disputing parties to exchange facts and information, such as a respective expert testimony, the parties can reach mutual understanding and settle the case. Absent settlement, information gained during discovery is presented during trial. Contrary to popular notions about court trials, neither party can spring a surprise on the other by introducing new and undiscovered facts.